and trademark copyrights and matters of unfair competition. Tonight we have presenting for us John Vidopia. He is here to teach you how to protect your intellectual properties so that you don't get caught up, and how the right way to go about it for your small business. So John, when you are ready, you can go right ahead if you want to give a further introduction about what you do on a day-to-day basis and go into your presentation. We are ready for you.
Hi. Well, thank you for the introduction. Let me just say that, so I started out, I was just talking and mentioning that I went to Brentwood initially, and then I ended up getting a 2-year degree from Suffolk in Selden, and it was technical. It was like engineering stuff. And then I got a 4-year degree and then went on to become a patent attorney. I became an attorney, and because of the technical background, I naturally focused on patents. And when businesses that have patent rights typically have a product out there, and products generally have trademarks that identify it as a source of that particular product, right? If you got something good, people want to try new products with your name on it. And then of course the stuff that's, again, if people are building something and putting money and effort into it, sometimes there's works like software or a website or some kind of writing that deserves copyrights. And so that's what I do. They call it intellectual property, and it's patents, trademarks, and copyrights. And from my perspective, I came in kind of from the technical side, which is like patents and trademarks, and where copyrights are more non-technical. At any rate, that being said, so in the United States, what happened is the Constitution enabled Congress, to pass laws to protect patents and copyrights, not trademarks at the time. Trademarks were like common law, and they came from Great Britain, and they weren't the same thing coming from Europe. So at any rate, kind of funny, so at the time of the Constitution, right? This is a while ago. Congress the Constitution empowered Congress to make the laws, and the patents laws. I don't know if you know how it works. So Congress writes these laws. They love writing laws, I'm sure, and they classify them like in different titles. And so patents are 35 USC, so it's Chapter 35 of the United States Code, and the copyrights are 17 United States Code. And back to the trademarks that weren't mentioned in the Constitution, they did come around. Trademarks came around and were codified as federal law in 1870. I'm not sure what was going on at the time, but I guess people didn't like it because they sued and rendered the Trademark Act of 1870 unconstitutional. And then around 1881, there was a second Trademark Act. There was the Lanham Act. And since then, there's trademark law. And anyway, I hope I'm not boring the heck out of you with that. So at any rate, as I mentioned, copyright 17 USC. And so it protects the material itself, the tangible form of the work, and not the idea. For example, if you wanted to do this, you could prepare a phone book, and you'd have everybody's names and addresses in the phone book. Well, your copyright for that phone book would protect the arrangement of everybody's names and phone numbers, but it wouldn't protect the data itself. So I could go in there and grab your phone book and shuffle it about and republish it and not infringe the copyright. Anyway, again, copyright law covers the particular form and the manner of the work. They could, whether it's a musical performance that's recorded, it's videoed, a publication, that they call it a work in copyright law, in IP law. Anyway, And so, oh yeah, so that was it was the Copyright Act. Anyway, it was modified in 1976. And so what it covers is literary works, musical works, dramatic works, pantomimes, pictorials, paintings, motion pictures, sound recordings, architectural works, and computer programs. And what you get when you, and so there's also, it came here. So we're a common law state. Europe is kind of, is not a common law state. It's a civil code state. And the common law comes from the Brits. And so we had copyright law in the common law in this country, in this part of the world, before it became the United States, because the Brits were running the place for a while, and they're the guys that invented common law. And so what happens is that even without registering a copyright, once you put something in an original, in a tangible form, like you create a Word file or a PDF, or you print it out of a computer, or you paint something, you paint a mural on the wall and take a photo of it. Once you do that, you accrue common law rights to it. But the way the common law rights work, because there's no codified common law under the federal system, you'd have to sue everybody that infringes in each state. So if if there was a big entity like Target was infringing it in 50 states, you'd have to sue Target in every 50 state, unless you get a federal copyright registration. It gives you all kinds of great rights, including to reproduce the work, prepare derivative work, distribute copies, display the work publicly, authorize others to use, and of course, sue ham and eggers that infringe your rights, that make copies without authorization. Current term of the copyright for an individual is 70 years plus the life of the owner. Like if I had a copyright and today was my end, it would go on for another 70 years. A work for hire is something, it's like any work, again, when it comes out of the printer, when it comes off the keyboard, it's building common law rights. And so if you hire someone to build you a website or do something for you, you need to have an agreement that's a quote work for hire agreement, because the work for hire agreement is the only thing that will clarify your rights to what the work for hire contractor is doing for you. Essentially, it says, hey, I'm doing this for hire, and Vidopia has all the rights no matter what happens. And that has a different term of protection. That's 95 years from the publication date, or 120 years from the first creation. So maybe it's a good thing to hire someone to get your copyright stuff. They go for 120 years. At any rate, I have a little comment. Mickey Mouse, 1928 to 2003 would have expired, but that 1976 copyright law, Congress changed the law from 75 years to 95 years. So Mickey Mouse has still got some traction. Yeah, I guess that if you go to Disney World. Anyway, sorry. So copyright infringement. So the thing about copyright infringement, like look down here at the bottom, an infringer or copyright is liable for $7,500 to $30,000 for one copying. And that's the funniest thing. Like the people that influence Congress to implement these laws, like the Copyright Act, they did a good job, because that's pretty onerous. So I have a client, and the client inadvertently, right now I have a client, and the client inadvertently copied an image for a website from a website, right? He just saw this image, and it was of the name of a town. It was a sign identifying the name of a town on Long Island, and he used it as his website. And the people that own this drawing, this work of this photograph of this sign of this town, like in the town, there were a couple of kids crossing the street in the photo. Instead of contacting him and saying, hey, that's our photo, take it down. And by the way, the photo was my client reproduced on his website it wasn't the full photo, it was a thumbnail. And so at any rate, instead of calling them, because we found out in the complaint that they knew about it for 15 months, instead of, letting them know, even sending them a cease and desist letter saying, hey, you're using our photo unauthorized, take it down, or whatever. They sued him. And they're looking for significant money. They're looking for between they're looking between 20 and 25,000 bucks for one copy. Anyway, it's like a cottage industry. And so at any rate, the thing is, do you defend or do you just throw them some money to go away? Because if they have you, they truly have the guy because he did make the copy and use it as his website. So they sort of have him. But at any rate, there's something called a fair use exception, and that's what we're relying on. And we have a fair use argument, but there's something else, and I won't go into the fair use too much, but it means that there's like an affirmative defense to the infringement. But there's also something where it's almost like fall on the sword. There's this law, I think the statute is 501, right? There's a 504, this is 504A, but 504C2 says that the federal judge, if the equity allows, can cut the award down to 200 bucks. In other words, if there's non-intentional infringement, if it was inadvertent copying, if the guy didn't make any money on it, if as soon as he got notice, he took it down, because he just wasn't trying to rip anybody off. Anyway, again, in addition to a fair use affirmative defense, there's that offense of innocent user where, again, if the judge believes you, he can do you right and award the guy only 200 bucks. At any rate, we made them an offer. And we'll see what happens. Oh yeah, and so I think I went into this about the common law of the copyrights. Registration with the U.S. Copyright Office is not necessary, but it has its advantages, and I won't repeat myself. Yep. Okay, and so, and the funny thing, so the whole thing about this is that in 1989, so when I started practicing, I was practicing before 1989, you had to, on a copyright, you needed to get paid if you wanted to get damages for the damages clock to start ticking. You had to have a copyright notice. That is, say, John Vidopia, 1974, or something like that. They changed that in 1989. So now you can see a photograph and think it's in the public domain and you have the right to use it because there's no copyright notice. You could be wrong. You could get a cease and desist letter. You could get sued like my client, for like one thumbnail of what, and it wasn't even like it, I don't want to talk bad about the photo, but I'm not saying there wasn't anything stupendous about it either. You know what I mean? Like that it's worth 30 grand. I mean, my God. Anyway, all right, last thing about copyright law. I hope I'm not going too slow. This is something that's pretty important today, the Digital Millennium Copyright Act, the DMCA. So this is part of the copyright law. It went in 1998. And what it does is it exempts internet service providers from liability for what people post, for example, on a board or, at some wherever you're at, whatever internet service provider, whatever app you're using, they're not responsible for what you say unless there's some complaints and they have to have a process in place to take the stuff down, and it needs to be sort of 3 strikes and you're out. There's a case out there that says that giving someone, an offender who was offending someone else, 13 chances didn't fly, and it stripped the internet service provider of the DMCA, whatever paragraph that was, the safe harbor provision. They stripped them of the protection of it. Oh yeah, here at BMG Rights Management. At any rate, was not entitled. So Cox was not entitled to the safe harbor defense, finding that Cox 13 strike policy for repeat offenders was effectively no policy at all. And so they paid. And anyway, make sure your website designer does it under a work for hire agreement. Anyway, we went through that. Oh, and this is what you need to do to not get sued for using someone's, if you find someone's image online and you want to use it at your website, you got to get permission, and you got to find out. Typically, everything's for sale. So you could find a photo and you could find out who owns the photo. The same guy that would sue you if they see you using it without permission, you could probably find him and get permission from him. So spend the effort. It's worth it. You don't want to have to pay a lawyer to protect your business because you made a silly mistake. Anyway, okay, so into trademarks. Trademarks are like this thing that it's this indicia that indicates a source of the goods or services that you're selling. And if you're selling high class goods, and people get to know it, you got a high value mark. You know what I mean? And then, and I'll just say this broadly. I don't want to repeat myself. I'm probably going to talk about it, but the more unique the mark is, when you create a mark, the less common word. You don't want to use common words. The more value it can accumulate. Not all trademarks. It depends on what they are, how they're formed. Some of them are just too common because they're not unique enough to accumulate real value. And the more common a mark is, the less trademark value it has in a court of law if you ever accuse someone of infringement. Anyway, I'm getting ahead of myself. So at any rate, yeah, this is Title 15, Chapter 15 of the United States Code, and it's anything. This guy got a trademark for that, for his representation with the M, which is kind of unusual. They would have never given it to me if I was his lawyer. I'm joking. Anyway, this guy got a mark for his yell. I'm not going to do it. I can do it. You want me to do it? No, I'm not going to do it. Okay. And then a service mark is just services. There's 34 goods classes. If you file a trademark application, you have to, depending on what you use the trademark for, you have to pay by class. And so the trademark office divvies up all the goods in the world in 34 classes. And if you got some overlap, like t-shirts is 25, games is 28, clothing is 25. Anyway, sometimes you're going to file in 3 classes to cover effectively your sets of goods that you might be selling under the mark, and the trademark office makes you pay. It's like $350 for each class. So instead of filing, and it costs you $350 to file in 1 class, it could cost you $1050 in 3 classes. At any rate, so the bottom line is that there are 34 goods classes and there are 11 services classes. The service mark is a trademark as well. And again, and if they can, they're going to invite you to, you're going to file an application and they're going to invite you to expand it into other classes. And you don't have to do it if you don't want. You can tell them, no, we're not using those. So at any rate, that's trademarks. Trademarks are relatively cheap. They go forever as long as you don't fail to police the mark and you just take care of your mark. They don't have a term. They don't end the way the copyright ends after about 100 years. You could lose your mark though, but I won't get into that. Oh yeah, so a registered trademark's got that superscripted encircled R. Until you get a registration, even if you file an application to register, you can't use that encircled superscripted R until the registration issues, till the application passes to registration. And so, but before you do that, there's a common law designation, and that's a superscripted TM or a superscripted SM. The TM for the first 34 classes, and the SM for the 35 to 45, the service classes. And that puts the world on notice that while you don't have a federal registration, it takes the encircled R to indicate a federal registration. Again, while you don't have a federal registration, you intend to protect the mark and you're indicating that you're going to secure that you're securing common law rights with use under with that indicia, that SM or TM. Okay, enough out of that. And then yeah, as I said, 350. Oh, and so you can file two ways. You can file a trademark application if you're using the mark, right? Because you have to use the mark in commerce before you can get a registration in the United States. Not like that in most of the world, but in the United States, you got to use the mark and evidence using the mark. And so you can file under Section 1A, which is a use mark, or you can file under Section 1B, which is the intent to use part of the statute, 1B as distinguished from 1A. And so you haven't used the mark, but you're staking it out. You get into the trademark first. Well, at some point, you got to start using the mark in commerce. And when you do that, this is going to cost you a little extra. You got to pay them $125 a class and swear that you're using it in commerce, and also upload an example. For example, a JPEG or a PDF file of some capture of some indicia of use of the mark, either selling the services or selling the goods, again, in commerce. And it's called statement of use. At any rate, once you do that, well, then you can your application will issue as a registration. So the main requirement, and this is the last thing I'm going to say about trademarks, it's got a funny standard. What they do a search and they compare your mark. Sorry, when you file an application to register a trademark, the examining attorney is going to pick it up, going to look at your mark, and he's going to do a search and see if there are other marks that there might be a likelihood of confusion with your application and with existing registrations. And so it's not confusion, right? It's likelihood of confusion. At any rate, so I'll tell you a little about it. It's like that a customer will buy a product believing he or she is buying someone else's product. That is because the mark's real close and the goods are relatively close. And so it's not just the marks. And by the way, the standard is the spelling, the appearance, the sound when spoken, and the connotation, right? What the mark conveys when you look at it, and then the overall commercial impression of the mark. And so that includes the same kind of goods or services, like that's part of it. It's not just what the mark looks like. At any rate, it's likely a customer will believe that a particular entity has sponsored or approved the item bearing the mark, of the two entities using the mark or a similar mark competing, and they in the same field. And then I guess there's other things that distinguish it. But if you get a likelihood if you get a refusal to register your application based on likelihood of confusion, you have to respond and you have to file a response, and you need a well-reasoned argument why there's no likelihood of confusion. At any rate, I've probably spoken enough about that. Trade dress is the way your product packaging works, and they're extending it they're trying to extend it. I think the law is sort of extending into and kind of defining protection for web pages, like sort of under the Lanham Act, under the trademark law, as trade dress. But anyway, it's sort of subtle. And so at any rate, any trademark rights don't arise unless what's acting as the mark or the trade dress is distinctive. At any rate, let's get on to patents. Let me just check the time. And I think we got some time. So chapter 35 is the one that controls and regulates patents. And so there's this law, I didn't mention this, but 35 USC, skip that. 35 USC 101 says that whoever invents or discovers any new useful process, machine, manufacture, or composition of matter, they're entitled to a patent, except for a few exceptions. The invention, it's got to be novel, under this law called 35, chapter 35, right? 35 USC 102. And it also has to be non-obvious under 35 USC 103. And it also has to comply with 35 USC 101 and this other one called 112. At any rate, sorry about the numbers, but this 35 USC 101 is pretty important. It's pretty topical right now because the law was always, the patent law has been around for 250 years, right? So it kind of evolved into computer stuff. And then it sort of evolved into, like, how can we protect, a computer invention? And so it's one thing to have hardware protected, that's computer related, but it's another thing to have software protected. And so the way they do it is they do it with a process, a method claims. And so method claims protect software. And so when they started allowing patents on software, they started cutting back on it because they wanted to make sure that people weren't using a digital computer, you know what I mean, this new technology, I'm talking about the last 30 years, to protect stuff, to implement an application, to write an application that implements an existing process and kind of takes the existing process, almost like the analog process, take it out of the public domain. And so they started cutting back on it, and it's about this law 101. And so at any rate, there's exceptions. You're not allowed, sorry, it's the right 101. There's these exceptions. The exceptions are you can patent anything under the sun, essentially, but for abstract ideas, mathematical expressions, and naturally occurring things like bacteria and the like. Anyway, let me get you a little more of this writing. And so before getting into that, so I don't know if you know what a patent is. So let me tell you what a patent is. I should have told you that already. So a patent is this writing. You take a Word document and you talk about what you think's inventive in the Word document, and hopefully you have some drawings, right? And in the Word document, you're talking about what's inventive, and you're talking about like an example of it and maybe a picture of it in the drawings with some numbers that identify the different elements. And again, you're writing about it and identifying those elements by number in your Word document. And when you're finished, you claim it. And a claim is this thing where you say, well, my invention comprises a software application for modifying bagel cooking temperatures, comma, the software comprising the steps of, and then you write it all out. And again, it's a Word document. There's a PDF, you turn your drawings into PDFs, you send them to the patent office. And if the patent office thinks it's okay, it allows the application and it just prints it out in a patent form. It's your Word document, but they make it kind of nice, in a nice form and everything. And it's got the claims at the end, and that's your patent application. And the value of it is what those claims capture. You know what I mean? If it captures every bagel store in the United States, you got something going there. But if only captures one in Ohio, well, then is it worth suing them? At any rate, that's why I say the most important part of the patent is what it claims, which defines the metes and bounds of protection, the capturability. Another way of saying it is the claims is where the money is. Anyway, and again, patents can generate royalties. I'm going to go for this. I'm going to try this. So it's a very strange thing, patents. You get a patent, and if someone operates according to your patent, you can sue them for infringement. You can demand they pay you a royalty. You can get a license with them where they agreeably just pay you a royalty, 3 or 4% on everything they sell, something like that, right? And so again, that's what the patent does. If they practice your invention without your permission, for example, under a license, you can send them a cease and desist, sue them, whatever, because the patent gives you the right to prevent others from making and using the invention. A funny thing about what I just said is it doesn't say anything about giving you the right. If you get a patent for an invention and it's an improvement on something, for example, it's for a military tank, which is an improvement on a four-wheel drive automobile with a motor. If there's a patent for the underlying technology, you could get a patent for the improvement, but you can't practice the improvement without getting sued without a license from the guy with the underlying technology. And so even if you have a patent, doesn't mean you can practice it. Okay, so let me see. I haven't read this for a while, but for example, if inventor Mr. Smith gets patent claims for an apparatus comprising 5 elements, A, B, C, D, and E, and Mr. Jones already has a patent claiming A, B, C, and D, Mr. Smith cannot practice his patent even though he has E, because he's also doing Mr. Jones patented A, B, C, D. He's got to get a license from Mr. Jones to practice A, B, C, D, and E. Again, it's a very, it took me a while to get this concept. Okay, so what kind of patents are there? Well, there are non-provisional utility applications, non-provisional, well, there are design patent applications, there are plant patent applications that turn into utility patents, design patents, and plant patents. However, there's something called provisional patent application that some people would confuse with provisional patents. There's no such thing as a provisional patent. A provisional patent application is just that Word document and the drawings that comprise a patent application that you can throw together and file. But the thing about the provisional patent application, it gives you a patent pending serial number as soon as you file it and pay your fee, pay your $120. But it's like a time option. It gives you 12 months to take it and turn it into a full non-provisional patent application. And so a lot of people, they go with the cheap, they file the provisional application, they get this stuff to the patent office because it's a first to file country. And then they shop it around for a year and see if there's anybody interested in giving them some money to develop the underlying technology. And that's kind of the way it works. And a lot of startups rely on the provisional patent applications. Again, it's $120. You know what I mean? Like, no big deal. I mean, if you do it yourself. And so you can do it yourself. I advise hiring a patent attorney for a lot of money. But again, if you don't want to hire a patent attorney for a lot of money and you got to do it yourself, the most important thing to remember about the Word document, the drawings, is that you can make mistakes. You don't have to be perfect. You don't have to be pros. It has to be that if the patent office reviews it and reviews your claims and says, does this guy know what he's doing? The standard they're going to say is the technicality of the technology, right? The sophistication of the technology, the person that has that skill in the art, right? Whether it's, somebody making baseball bats or somebody, making ground-based radars for the Air Force, right? One who has the skill of a radar guy, as distinguished from a bat guy, right? That's the standard that the patent office and a court of law will judge the competence of your disclosure. That is, the judge will look at it and say, would one skilled in the art get what this inventor is saying with all this writing and all these drawings? And if you can answer, yeah, one skilled in the art would understand what the inventive juice is, where the invention lies, then you're fine. You know what I mean? And you don't need a patent attorney. And the bottom line is that, again, so the other side of that is that when you write you don't need to have it be prose, your provisional application, But if you're going to take that provisional application, not only does it have to be competent at the patent office when you file it, but you're also going to be shopping it around to venture capital, and you're going to be saying, hey guys, look, here's my invention. So do a good job. But again, you don't have to be perfect. Anyway, I hope I didn't beat that to death. So yeah, anyway, and it started around 30 years ago, 28 years ago. And now it's so small entities pay the middle price. The middle price actually was up at 150 and just went down to 120 in January. So it's like 240, 120, and 60 for a micro entity. A micro entity is anybody making less than 180 grand a year and having less patent applications. So actually, guys going to Suffolk, likely few of you make 180 grand a year. So your price would be 60. So if you got something, write it up. For 60 bucks, you get a year. You know what I mean? Probably better than the stock market. Well, I don't know. Maybe not. Don't quote me on that. Okay. So yeah. Oh, so that all that business that I was telling you about, this whole thing with the level of skill in the art, it's codified in 35 USC 112. That's the fourth law I mentioned. You gotta comply with 101, 102, 103, and 112. And then you're golden. There we go. Yeah, more about 112. Yeah, it's the written description requirement. And so it must adequately support the subject matter claimed, and so that the skilled person can reproduce the invention without undue experimentation. And without undue experimentation is this two-word phrase, three-word phrase. And that was like 3 law cases, to like without undue. So you don't have to be perfect. That's the undue experimentation thing. At any rate, these prices are so right now that price 785 just changed too. So I generally, most of my clients are 785. They're small entity. They're not large entity and not micro entity. Small entity now is 644, and I think micro entity is like I don't know, maybe it's 330 bucks, something like that. And a large entity is double a small entity. So I hadn't updated this. Sorry. Oh, right. And so this is another way. So the MPEP is this bunch of rules that the patent office. So the Constitution enables Congress to make the law, and then Congress enabled the executive to make rules. Like the patent office and the EOC and the FDA, they're not part of the lawmaking body like the Congress, House of Representatives and the Senate. The separation of powers. They're under the president. They're like different. And then there's the courts that are different. There's 3 things. Yeah. Anyway, the MPEP is not the law. It's coming from the executive branch, but it's the rules, the patent office rules. It took me a while to get it too. Anyway, there's some protocol, for drafting this stuff in the full patent application. Again, not the provisional. You can do whatever you want in the provisional. And so again, I talked about the patent claims before. In the non-provisional, in the full patent application, the claims must commence on a separate sheet. Each claim begins with a capital and ends with a period. It's all one sentence, even if it's 2 pages long. A little archaic. Again, this was codified for the first time in 1790 or something, so it can be a little dense at times. And then design applications, therefore, like the way a phone looks, like there was a big case, Apple against Samsung, where Apple won like $1.2 billion, and then they shaved it back down to 400 million. And again, it was just like the difference between like Samsung phones, what are the name of them? Anyway, they had a couple of features that were too close to the features that Apple had, the way it looks, you know what I mean? Like it's probably close to trade dress even. But the bottom line is that the thing about design patent law, design patents are kind of strange. However, damages for designs is the entire profits. And so that's what this business with the going from 1.2 billion to 400 million, you know, in straight patent law, like a utility patent, it's just like kind of like 2 or 3 times a reasonable royalty. It's not disgorge all profits or blah, blah, blah. So at any rate, if you can get a design patent and you can assert design patent against, against an industry, your patent attorney would get rich, which is not a bad thing, right? Anyway, that's a joke. Sorry. Anyway, I know nothing about patent applications. International patent applications, once you file a provisional, or if you don't file a provisional, you just file a full patent application, you have 12 months to flip it into the international arena, and you could file it right. Actually, you could file it right away too. You could file these right away. But at any rate, you can file an international patent application, which then gives you 30 months from the first priority date to take it into 30 months, 2.5 years, into 169 countries in the world, including the United States. So you can file, instead of filing in the United States a patent application, you can file it internationally and then wait 30 months. And so sometimes big business does this. Then they got this patent application on file and other people could build a market. The patent comes out 4 years later and they start suing people that have built the market in the last 2 years. It's like a cottage industry. Anyway, the bottom line is that you can file internationally. I actually, that's like part of my practice. I do a lot of phone work, and most of the half the phone patent applications that I file in the United States, I also eventually file under the Patent Cooperation Treaty internationally, so that they can go into other places. Anyway, so you can do a search, right? So you come up with an idea. You say, "Wow, should I invest any money in this? How do I know if it's patentable?" And so just make sure you clearly understand your idea, and then you can go to the USPTO and you can go to TESS, not TESS, sorry, that's trademark. You can go to the USPTO.gov. You go to their landing page, you click on patents, you click on search patents, and then you can put in 2 words. You can add 2 words. And if you come up with 10,000 hits, add another word. Keep refine your search and poke around, and you'll get to where your stuff is. When you keep qualifying and modifying your search string till you come up with 10 to 25 patents that are kind of right around you. And if you're not in that 10 to 25, well, then you're good. And if you are in it, go back to the drawing board, modify your patent. So I do this informally, you know what I mean? Like I'm suggesting that you do. There's a way to do it formally rather than do it yourself. What I do is I have a service that I provide patentability opinions, and so I charge a significant amount of money. I mean, not $5,000, but what I do is I kind of distill your disclosure down to 1 page in a drawing, and I send it to these guys that I use in Washington or in other places, actually, that all they do is they search patents, and they're much better at searching patents than me. And they come up with 15 or 25 patents that they think are real close, and they send them to me. And then what I do is I go through the patents and I compare your inventive subject matter against these patents that came up in the prior art search. And I figure out if you have a problem or not and write about it. And I give you a patentability opinion. At any rate, that's a bit more formal. And again, it costs some money. And so if you only have a little money, it may be prudent and pragmatic to just spend a little bit of money to file a thing. Don't worry about the search. Anyway, I don't mean to lead you down the garden path, but again, that could be a good idea. And I'll further comment that searches are inherently defective. Even the search that I send out to the guys where I'm paying them, and that you're paying me and I'm paying them part of it to do the search, right? So they know what they're doing. They're not the patent office. Only the patent office can do an effective search. So you paying a patent attorney to do a formal search there's an inherent defect in it. That is patent applications that are filed and patent applications that are filed. So a patent doesn't get published till the patent issues. It usually takes more than 18 months. Patent applications get published in 18 months. The only thing I can search when I search, or the guys down in Washington that I pay to search, the only thing they can search are databases that are up to date with the recently issued patents and recently published applications. And if the stuff is at least 18 months old, well, then your search is inherently the last 18 months are blind. And so your search is imperfect. The last, if it's new, if it's software, if it's quick moving technology, if it's an app, on a phone, something new, something that other people could think of or might want, something desirable, that 18 months might matter. So I think it's prudent and pragmatic to get your stuff to the patent office, the trademark office too, damn copyright office too. But we're first to file now for the last few years. Got to get there first. So at any rate, I can't emphasize that enough. I think that is about enough out of me. There's non-disclosure agreements, that there's all kinds of stuff. But I've talked enough. It's 7:54, and I'd welcome any comments you guys might have. I'm going to stop sharing the screen so that I can see you. All right. Or not.
At this time, if anybody wants to unmute or raise your hand or put any questions in the chat, you're more than welcome.
Oh, so guys, there's something I forgot to mention. You see that first slide? That's my name and email address and phone number. If you ever have a question, just give me a shout. No problem. In other words, just give me a shout and I'll answer your question. It's my pleasure, kind of. You have to listen to me then. That's all. That was a joke. My kids don't laugh at my jokes. I don't know if you guys are laughing. Any questions?
I am monitoring the chat. There haven't been any questions yet, but I will keep checking just in case it takes a minute to type.
Okay, great. Oh, but they can unmute and just chat, right?
They do have the capability to unmute if that is preferred. I'm not sure if everyone's microphones are working, but everyone does have the capability to unmute if they would like.
Yeah, it's funny. I hate working on a laptop, but my desktop doesn't have a microphone, so I got to use I got to use my laptop. Anyway, as far as patent attorney trivia goes.
All right, we're gonna give it just another couple of minutes, so people can, get their thoughts together, see if we have any questions come in before we close out for the evening. Alrighty, so I don't think we're gonna have any questions come in. However, I did put the center's contact information in the chat, so if any questions do arise, I can connect you with our clients.
Good. Okay.
righty, everybody. So I want to thank you again for joining. Thank you so much, John, for your presentation tonight. I will keep up to date with you and I'll follow back up with you tomorrow. I want to wish everybody a good evening and great health. And thank you again for attending.
Thank you.
Good night, all.